It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context. National capital is under a siege. You take an example. National capital is under a siege. There came to be three categories consisting of the nation. A, federating states, full-fledged states like Maharashtra, Gujarat, etc. Second, union territories without legislature. And third, union territory with legislature. That happened by an act of parliament. And something would turn when I respond to my learned senior, my Lord Dr. Singhvi's submission regarding, my Lord, that Puducherry has that, etc., etc. It is that union parliament's law which permits. My Lord, then your lordships may, there are salient features, my Lord, of Government of Union Territories Act, which I may not, my Lord, trouble your lordships with. Next is para 27. I'm sorry, page 27, that is Delhi Administration Act. But kindly see that only first para 48. In 1966, Delhi Administration Act had been passed to provide for an elected body of Delhi Metropolitan Council, which may propose, recommend legislations to be passed for Delhi. This had provided for direct election from different constituencies for electing metropolitan councillors. This elected body, to be known as Delhi Metropolitan Council, was in addition to the provisions for direct elections of councillors to the MCD under the 1957 Act. So for the first time, Lord, Delhi Metropolitan Council comes into existence, not the Legislative Assembly. That's all. That's the as a part of the narration. Now comes, Lord, the most important part. Lord, there was a wish, desire, and hope of the people that we must have an assembly. The Parliament, Lord, the government of the day, constituted a commission headed by Justice Sarkari. One of the members was Mr. Balakrishnan. Lord, incidentally, Justice Sarkaria completed virtually the substantial report. He worked for 13 long months, Lord, on this report. And thereafter, Lord, he was requested to be the chairman of the Press Council of India. And therefore, he demitted the office from the commission. Therefore, when the report was presented, it is known as Balakrishnan report, my Lord, but it essentially is a joint report substantially prepared by Justice Sarkaria. Nothing turns on that. It nonetheless is a report, but it is a report by someone, my Lord, having legal acumen and who has done a remarkable job, Lord, in his Sarkaria Commission report defining center-state relationship. My Lord, pausing here for a minute, my learned friend made extra efforts to ensure that your lordships do not go through Balakrishnan report. Lord, Balakrishnan committee report is necessary for two reasons. Lord, Balakrishnan committee report became the basis of the 69th constitutional amendment, which introduced 239AA. It is the basic foundation. That is number one. Number two, the then Home Minister, while introducing the 69th Amendment Bill, in more than one places say that this entire bill is structured based on the recommendation given by Balakrishnan Committee. And third and most important, my learned friend read only one paragraph from the majority judgment of Honorable the then Chief Justice Mishra, that we need not rely upon Balakrishnan Committee report. But I will show para after para. I'm not saying that I'll read. I'll show para after para that Justice Deepak Mishra relies upon it. My Lord the Chief Justice of India, in a separate concurring judgment, in detail relies upon it, and entire reading of the judgment, my Lord, in right perspective, would leave no room for doubt that your lordships have relied upon Balakrishnan Committee report to arrive at the conclusion. This is like, Lord, Parliament, Lord, Constituent Assembly debates as to what was in the mind of the framers. Because the Home Minister says we are basing this entire amendment based on this report. Now, please see, my Lord, the speech of the Honorable Home Minister. While introducing this 69th Amendment, which brought Article 239AA, which we are assisting your Lordships with right now. Lord, your Lordships may kindly come to page 28, para 54. Does your Lordships have that?
Yes.
The debates in Parliament while introducing the Constitution 69th Amendment Act leave no room for doubt. My Lord, I'll just reading. The speech of the Honorable the then Home Minister conveyed the following to the House. As the House is aware, Delhi is a union territory administered under Article 239 of the Constitution. 239 was there since 7th Amendment with administrator. Under the existing law, namely the Delhi Administration Act, there is a Metropolitan Council with elected members and an Executive Council to assist and advise the administrator in the exercise of his functions, other than those in which he is to exercise his discretion. The Metropolitan Council is only an advisory body with no legislative powers. There has been persistent demand for a representative form of government in Delhi and also for removing problems faced by the common man, such as multiplicity of authorities with overlapping functions. With a view to finding a permanent solution to the problems, the government appointed a committee on 24th December 87 under the chairmanship of initially Sri Justice R.S. Sarkar, it should be Sarkarian, and subsequently Sri Balakrishnan with wide terms. Lord, I have given the constitution or composition of the committee at page 28. From the beginning, it is Justice Sarkaria as chairman, Ramesh Chandra, former Secretary, Urban Affairs as member, and Balakrishnan, advisor to the Home Ministry as the member. So he was there, my Lord, from the beginning. Thereafter, my Lord, the Honorable, the then Honorable Home Minister discusses, my Lord, what is the, Lord, kindly see page 29, unnumbered para 3. It also examined, it means Balakrishnan Committee. It also examined the detail of the arrangement made in national capitals of other countries with a federal setup and took note of views expressed in the debates of the Constituent Assembly and Houses of Parliament on various occasions in regard to the arrangements for the capital. It also studied the recommendations made by the earlier committees and the commissions. The committee was aware of the complexities involved in designing a proper structure of government for a national capital, particularly for a country with a federal setup. Two conflicting requirements have to be reconciled. First, the requirement of satisfying the democratic aspirations of the citizens of capital to govern themselves in consonance with the spirit of the Constitution is very important. Secondly, as has been recognized the world over as well as in our country all along, the national government should have sufficient control of the capital city and its administration for discharging its national and international responsibilities and commitments. Further, the effective administration of the national capital is of vital importance to the national government for ensuring the requisite degree of security and administrative efficiency. In addition, there is the need to preserve the cosmopolitan character of the capital. The report of Balakrishnan Committee has attempted to design a government structure for Delhi, which would secure a reasonable balance between these requirements. The committee has come to the conclusion that on an objective appraisal of the aspects, any arrangement that involves the constitutional division of functions and responsibilities between Union and Delhi administration will be against the national interest and should be ruled out, and that, therefore, Delhi should continue to be a union territory with a legislative assembly with appropriate powers. It has also recommended that subjects of public order, police and land should be retained with the center as they are matters of vital importance for which the responsibility cannot be divided. This is also broadly in line with the provisions made in Government of Part C States Act 1951, enacted by the Constituent Assembly, sitting as Parliament. The details of the new arrangement for the national capital will be clear from the provisions of the bill, and I do not propose to go over the same. After carefully examining the report of the Balakrishnan Committee and considering all aspects, it has been decided to enact legislation generally on the lines of recommendation of this committee, and the bill seeks to make appropriate provisions in this regard. As the House may be aware, on earlier occasions, whenever a democratic setup was considered for Delhi, such as Government of Part C States Act, and also under the bill introduced in 1978, necessary provisions for a democratic setup were made under a parliamentary law enacted in performance of Article 239A. However, in case of Delhi, which is a national capital, the committee has recommended that provisions of the democratic setup should be incorporated in the constitution itself with a view to securing a measure of stability and permanence, and also giving a special status to the national capital. Delhi as the national capital has a unique status and certain distinguishing features. In view of the importance for the country as a whole, it should inspire a sense of belonging to all the states, which cannot happen if it is located in the territory of or be controlled primarily by a single state. The arrangements made in this regard to the national capital in other countries, particularly those with a federal setup, and all the thinking that has gone into this subject so far, fully support the view that national capital should be under the full control of national government. Lord, this is precursor to 69th Amendment, which introduced 239AA. The Home Minister says so while introducing the bill. At no point in the past has it ever been considered possible to make Delhi a full-fledged state. The Constituent Assembly went into the matter in great depth. It was observed during the debates that in the capital city, a large federation like ours, the arrangement should be that in the area over which the federal government has to function daily, that is the national government, practically in all details, the government should have unfettered power which is not contested by another, and subordinate legislature. This is the intention, and this is how, in my respectful submission, 239AA will have to be read. The States Reorganization Committee and all other committees have reached the same conclusion. Several important national and international institutions like the President, Parliament, the Supreme Court, etc., as well as all foreign diplomatic missions, international agencies, etc., are located in Delhi. It is also a place to which high dignitaries from other nations pay official visits frequently, and it is in the national interest that highest possible standards should be maintained in the administration of the national capital. It is also in national interest that the center should have control over the national capital in all matters, irrespective of whether they are in the state field or union field. Lord, I am not re-arguing the Constitution bench judgment. I am only confining this to the services and the control, my Lord, which the very foundation stone of 69th Amendment recognized. If Delhi is made a full-fledged state, it would be constitutionally impossible for the central government to intervene in any matter relatable to state lists, such as public order, public health, essential supplies, municipal services, etc. These are not illustrative. These complete constitutional prohibition will make it impossible for the central government to discharge its national and international responsibilities in relation to capital if Delhi becomes full state. Then 69th Amendment Act comes, which brings in 239AA. Now, this is, I'm sorry.
Yes.
Lord, this is the relevance of Balakrishnan report, and I will read it at the end using my discretion not to read which is not relevant, but to say that Balakrishnan committee report should be discarded may not be a correct assistance to the court. Lord, I am not relying upon, my Lord, I at the outset, my Lord, point out that wherever word state is used, union territory is outstate, that part of the commission I am not relying upon. That, my Lord, the Chief Justice of India has taken care, my Lord, in the Constitution bench. It has to be decided contextually, but to give context to the word insofar as it is applicable to union territories. Lord, your Lordship would examine whether a particular matter, Constitution doesn't use the word entry, particular matter is applicable to union territories. It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context. Lord, with special context with regard to Delhi emerging from the Balakrishnan Committee report. That complete control for various reasons. Lord, there has to be a lieutenant governor who is informed by the officers. Lord, nobody say the bureaucracy should be pliable bureaucracy. Lord, I personally had a very serious objection, though it was lightly said, monogamy, that permanent monogamy. No, bureaucracy is not wedded to any party, any government. Bureaucracy is wedded to the Constitution of India. But suppose national capital is under a siege. You take an example. National capital is under a siege. One arterial road, my lord, linking one section of the country to the capital is blocked with permanent structure. And if the government of Delhi sends food, it is the responsibility of the bureaucrat to inform the LG that this is the capital cannot be under the siege. That is the control, my lord, which is envisaged under 69th Amendment. If during the COVID period, the number of tests are brought down, my lord, with a view to ensure that the figure is good, it would affect, my lord, the future course of action the country would take nationally. The health secretary will have to bring it to the notice of the LG. That you cannot do that. At a particular point of time, the test has to be rigorous testing so that we know the real problem, whether we are dealing with a rat or with a dinosaur, so that the national policy can be accordingly framed. If we show only 10% are affected with COVID, though there are 500, Lord, we may have a situation where all high commissioners and ambassadors are affected, and the world over the message will go that the government of India is doing nothing. It is the national shame. Lord, therefore, I am not saying the bureaucracy should be loyal to the central government, but the central government must have a say. Who will be appointed and who will head which department? Then, as I have shown from the terms of business, he is bound by the transaction of business rules. He is reporting to the minister. He is taking orders from the minister. He is bound by the instructions of the minister. If there is any difference, it goes to the Council of Ministers. Council of Ministers is supreme. Collective responsibility, democratic functioning, everything is, my lord, I respectfully bow. But to say that once the officer comes under my jurisdiction, it's my decision what to deal with, how to deal with him, and what to tell him, that goes against the very spirit with which 239AA is introduced. Lord, now kindly, my lord, see, my lord, page 34, your lordships can just have a look. These are the judgments why the report which becomes the basis of a constitutional amendment is a good external aid for interpretation. I am not, my lord, reading it. Now, my lord, your lordships may come to 35. Your lordships have read and reread Article 239AA, but it would take 5 to 10 minutes, my lord, if your lordships allows me to read it, and your lordship reads it with me, the way, my lord, I perceive 239AA to be, which, my lord, gives the supremacy, not only to the parliament, but to the executive as well, because the executive function is always coterminous with the legislative function of the executive, my lord. Lord, 35.
Mr. Solicitor, instead of reading that, if you can just look at your para 67.
Yes.
You have highlighted some very important aspects of 239A. So we can read para 67 actually. Because you have paraphrased, which are those parts of 239A which are crucial according to your submission?
Yes, my lord. Only one thing before that, with my lord's permission. May I read 3A only first and then come to
All
67?
right. Yes, all right. We can read.
3A at 35.
Yes.
Subject to the provisions of this constitution. Kindly pause here for a minute. Lord, this includes sub-article 1 also, which reads, as from the date of commencement of the Constitution 69th Amendment Act, the Union Territory of Delhi shall be called National Capital Territory of Delhi, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. So, my lord, 239, original 239, which was brought in under the 7th Amendment, is applicable. Administrator does govern the Union Territory. And your lordships have accepted in the Constitution by judgment. Lord, 239 existed much prior to 239AA, which empowered administrator to control or to administer the national all Union territories. So that continues because it is subject to the Constitution, and which includes 239 and includes 239AA sub-article 1. Then, my lord, further, 3A. I'm sorry.
Yes.
No, my lords are jotting. The Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list. Please mark, insofar as any such matter, not any such matter is applicable to Union territories. Lord, plural. So the test in my respectful submission for your lordships would be a subject matter wise selection of implied exclusion. My lord, there are two exclusions under this. First is, my lord, insofar as any such matter is applicable to Union territories. That is implied exclusion contextually, as my lord, the Chief Justice of India has read, and I'll show my lord, those paragraphs from the judgment. That is implied exclusion from the subject matter. That this subject matter can't be in Union territories. And when you lordships test, it has to be whether Lakshadweep can do it, whether Goa, whether Div and Daman can do it, whether Andaman and Nicobar can do it. That would be the test. And second, except matters with respect to entry 1, 2, and 18, and so and so. Now B. Now, my lord, kindly come to 67, 37. My lords, my lord Chief Justice of India, my lord, very kindly indicated, para 67. A perusal of sub-rule 3 would show that the extent of legislative powers of the Legislative Assembly of NCT is consciously, unequivocally, and manifestly circumscribed by 5 modes. A. My lord, I have already pointed out, subject to these provisions of the Constitution. That is, administrator, govern Union territory, continues. And 2, the legislative power of Delhi government, Legislative Assembly to be in the, be it under state list or in concurrent list is circumscribed to the extent insofar as any such matter is applicable to Union territories. So, my lord, in other words, the legislative power of Assembly cannot extend to any of the entries in the state list or concurrent list if the state entries are not applicable to Union territories. It does not use the expression in relation to Union territories. It says applicable. My lord, applicability test is a rigorous test. It should be applicable. Relating to is a lesser. Then third is, my lord, specific exclusions, my lord. Those 3 entries and entries relating to them. Lord, again, my lord, the very same article first uses the word applicable. Insofar as they are applicable to Union territories, and then say entry 1, 2, and 18 of the state list and entry 64, 65, and 66 of that list, insofar as they relate to state entries. Lesser of the rigors, lesser of the test to be applied, and lesser of the threshold to be crossed while examining. Then 4, The legislative power of Delhi Assembly is further circumscribed by sub-article 3B and sub-article C of the Constitution. The parliamentary legislation can supersede the Legislative Assembly's Act in place. Since Article 239AA 3B and C is also part of the Constitution, this is circumscribed power conferred upon the Legislative Assembly. But kindly pause here for a minute. But what I'm trying to assist your Lordship with is this. But as my Lord the Chief Justice rightly remarked that for the purpose of Delhi, state list and union list, both state list and concurrent list, both are concurrent lists. Meaning thereby, the Parliament can make a law even from the state list, which is not permissible in case of federating states, which overrides the state list. Since the legislative power is coextensive with the executive power, when we read sub-article 3, subject to this constitution, would it not be, I'm posing a question to myself, subject to even 3B and C? Please, my Lord, read that. Again, my Lord, at page 35. Subject to the provisions of this constitution, then your Lordships have read, come to B. Nothing in subclause A shall derogate from the powers of Parliament under this constitution to make laws with respect to any matter for a union territory or any part thereof. So, the legislative power under A is subject to B because B is also a part of the constitution. And it starts with subject to the constitution. And C is, my Lord, supremacy. If there is a law made, then it would prevail. It's like, my Lord, 245. Then, my Lord, fifth, I'm on page 38. The fifth limitation on the power is to be found in Article 264 to 246.4, my Lord, which I have quoted. Please read, my Lord, at the foot. The title is Subject Matter of Laws Made by Parliament and by the Legislature of the States. My Lord, hierarchical list is given. First, union, then supremacy of the state, etc. But 4, Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, which includes, my Lord, union territory. Notwithstanding that such matter is a matter enumerated in the state list. This is the limitation on the power of Delhi Assembly and supremacy of the Parliament, which my lords have accepted in the Constitution bench. Now, your lordships, my lord, kindly, my lord, skip. I have reproduced, my lord, what the High Court has said. My lord, High Court accepted our proposal, my lord, our